All right, in this section we're going to discuss how this law did not apply to Gary and therefore he could not have been guilty of any crime related to it. The state claims that they own the water, all the water in Oregon. That's erroneous because those waters were never all given to the rule of appropriation, which is the authority by which the state is claiming. Remember, when we started all this, the waters belonged to the citizens, and we agreed to do certain things like give limited power to government so that they could regulate for the benefit of the general welfare and the public safety certain aspects of our lives. The tributaries, the streams, the oceans, certain things that affected us all, those were given in a limited capacity as a fiduciary responsibility to the state to regulate. The rainwater was not, it never has been, and it should never be. Here's why. When rain comes down, it falls across the ground and it's what's called diffuse, winter runoff. We don't have rain all year round. You can see around here it's already dry, and we're going to show some other clips later where it's very dry. What you have is winter rains several months of the year, and that water overflows streams, overflows ponds, overflows everything, and goes all the way to the ocean. Gary's water didn't interrupt the flow of any of that water. In fact, Gary's ponds don't fill until the ground is saturated. And the water that comes up in Gary's ponds, because he's at the top of the hill, he's not down on some bottom, he doesn't divert any water from any stream. And we'll show pictures to prove this. All of what we'll say, by the way, you can see the evidence backing up what our opinion is on our website, which is empoweringthejury.org. Please go there, take some time with it. It's far too important not to. So, we're talking about rainwater that falls from the skies, diffuse over the ground, and seeps into the ground and seeps into these ponds and fills them, and later percolates down through the soil and then goes on its way in the summer months when we need it most into the aquifers. It supports wildlife habitat, it cleans the water in the streams, it protects so that we always have wetlands, we always have environment for habitat to adequately have its life and have its rights. There's a difference between rainwater that is diffuse over the ground that has not entered a well-defined channel and water that enters a watercourse and becomes part of a tributary. The state is saying that they have the right to all of it now, when before it was clearly understood, and it was never given to them, by the way, in a right, that they did not have jurisdiction over the ponds that were filled with diffused rainwater, snowmelt. They call it winter runoff. There are statutes that are limited for a reason. If they're not limited, they include everything. The statute specifically includes tributaries. It does not include diffused runoff water. Gary's ponds are not filled by a tributary of any sort, and we can show pictures of that online, you'll see that. So what we're dealing with is that those diffuse waters are clearly not under the rule of appropriation. We have expert legal opinion on this from one of the best water law attorneys in 4 states. We have constitutional definitions of this. We have common law definitions of this. We have legal treaties written on this. There is a segment at which it changes from diffused winter runoff water when it enters a well-defined channel and enters into what they call a water course. We did not give them unilateral rights to control all the rainwater as well as what's in the tributaries. We were very specific about that when we formed these statutes. Further proving that point, the rights were all assigned from this particular area to the city of Medford to be used exclusively for municipal purposes, and those rights were withheld. They were drawn, the waters were withdrawn from appropriation and granted to the city of Medford in 1925. If the state is now going to say that that definition includes all the rainwater, well, then they didn't have the jurisdiction to issue all the other pond permits to all the other owners that are using it for purposes that aren't municipal. So clearly they've broken the law. In either way they try to decide this. You cannot take a law that doesn't apply to a citizen, imply it on him, take him to court, don't let the jury hear about any of the evidence related to the law, and find him guilty. The only reason that the jury found this man guilty is because they were not allowed to hear any evidence that showed that the law didn't apply to him. The judge very partially, meaning with prejudice against Gary, denied his right for the jury to hear that. The jury has the right to hear the law and the fact. That is well established in United States Supreme Court cases. The only reason the jury found Gary guilty is because they were disallowed from hearing the evidence by the judge. who felt that the evidence that Gary had in his defense might unduly prejudice the jury against the state.